made updates, and so my screen looks different. Great. Mine now says we're recording.
We are recording.
Wonderful. And then, so I think next would be housekeeping. Is that correct?
Yeah, I think we did we already call the
Oh, I'm
meeting
sorry.
to order?
Yes, please go ahead.
I'm calling the meeting to order.
And then housekeeping items. Kim, is that you today? Okay.
Hold on a second.
Sure.
Whew. Welcome committee members, liaisons, and members of the public to the Legal Services Trust Fund Commission Eligibility and Budget Review Committee meeting. Thank you for joining us. We are using Zoom with a goal to foster a more inclusive environment and effective meeting. If you would like to comment during the meeting, please use the raise hand feature. Please utilize this tool to virtually indicate that you would like to speak in order to help the chair facilitate the meeting. As a friendly reminder, this is a video conference meeting, and to please be aware of the surroundings behind you. All LFTFC and committee meetings will be recorded and posted to the State Bar's website. Zoom captioning is available. To enable, select live transcript at the bottom of your Zoom screen, then select enable transcript. Thank you.
Thanks, Kim.
I think we're ready for a roll call. Danielle, are you going to do that?
Yes. Blakemore,
Here.
Gonzalez,
Here.
King,
Here.
Klein, Morales, Vargas. So, I'll do advisor, non-voting members, liaisons, and staff in just a moment. But we have 3 voting members present and 3 absent, so we do not have quorum for this meeting. And we have received guidance that the meeting can still proceed forward, and the members that are present can discuss the items on the agenda. But any recommendations or votes made today would not be recommendations and votes of the Eligibility and Budget Review Committee. It would be only of the members that are present at this time, because we do not have a quorum for the committee as a whole. All right, so I will go and do advisors, liaisons, and staff. Judge Seligman.
Here.
Selena Copeland. I saw, yeah.
Present.
Laura Brown. I don't see Laura, but Melanie. Great. And then State Bar staff, we have Dwan, myself, Abraham, and Brady Dewar.
I don't see Brady.
Brady's in the attendee pool, I'm sorry. He is available and on hand for us, but it's not a candidate.
Right.
Great, okay. So again, we have 3 voting members present, 3 absent. We do not have quorum.
All right, so I think let's just take a minute to see if there's any public comment. Oh, and Ella, did you have a comment before we started?
I just wanted to let everyone know I'm going to step away for a minute because I realize I need to get a power cord for my laptop. So I'm going to disappear for like 30 seconds.
Okay, thanks for letting us know.
Yes.
So I also have a question. If one of the 3 absent members should show up at some point, would we then be able to develop a quorum?
Yes.
And is there any hint that that might happen? Oh,
Not as we understand it, no.
all right, never mind.
I think, is the rule technically if someone shows up and then they leave, it's still a quorum continues unless somebody says there's not a quorum, but you know.
Yeah, if you show up, even if it's for a few minutes and then you leave, we still have a quorum. But
Catherine, I believe you were asking for.
Yeah, I didn't know if we wanted to wait for Eloina, but let's just go ahead with public comment and I'm sure she'll be right back. Is there any public comment?
No, excuse me, no one has their hand raised.
Okay.
I do just want to mention there are 2 members of the public that are from an organization that we'll be speaking about later in the agenda, and so they may wish to make public comment at that time, but like Kim said, they don't have their hand raised at this point.
Oh, I see. I figured out the other person would be perfect. We can certainly take additional comment then.
Okay.
So we'll just proceed with the agenda, and I assume that since we don't have a quorum, there's not a reason to discuss the minutes, and we'll just approve those minutes at the next meeting, correct?
I think
Okay.
that's reasonable, yes.
Okay, so let's just proceed on to item 4, which are our business items. And the first is an update on IOLTA EAF prospective applicants.
Great. Okay, I will share my screen if you'll give me just a moment to do so.
Sure.
Share. This. Okay, great. So we provided a brief overview last time at the meeting about prospective IOLTA EAF applicants, and particularly new applicants we may receive in this application cycle. And so I wanted to provide another quick update on the status of those new applicants. Staff have spoken with about 15 different organizations that are interested in applying for funding as new applicants. Some of those, over the course of the conversation, it was determined either IOLTA EAF wasn't quite the right fit for them, or maybe they're not kind of prepared at this time to submit an application. So I don't expect that we will receive 15 new applications, but the applications are not due until May 15th. So there is certainly still time. As of yesterday, when I checked, there were 8 new organizations that have at least started an IOLTA EAF application that are not currently grantees. 7 of those organizations are proposing to apply as a QLSP and 1 as a support center. So I have a little bit of information that I can provide about each of those organizations, but I do not plan to share their names publicly because their application materials are not public until they are submitted. But happy to give an overview of what those organization services are and our understanding of their general org size and service areas. So the first is a new organization. They're actually kind of spinning out of a larger grassroots organizing nonprofit that's focused on racial and economic justice. They had an internal organization that was doing more direct legal services, and my understanding is that previously internal legal department is spun off and made its own organization, focusing primarily on impact litigation work, policy development, and direct legal services related to those issues of racial and economic justice. The organization from which they are separating has statewide services, so I would expect that this newer organization would as well, but they haven't yet identified in the application what counties they're applying for. Also, because they're newer, we don't have a great sense of their expenditures at this time. The second is also applying as a QLSP and runs a statewide hotline providing brief services to individuals that are concerned about a child in foster care. They focus on informing individuals about how to provide information to the court in dependency hearings. As I mentioned, they're also providing statewide services, but it looks like they're planning to apply in some of the larger counties where they're receiving most of those hotline calls from. So LA, San Diego, San Bernardino, Riverside, and San Francisco, based on their application materials thus far. And their expenditures are under $1 million based on their publicly available documents. They're about 700,000 in the last tax year available. The next is a QLSP that does direct legal services related to expungement, domestic violence and family law, and services to small businesses. They serve, from their website, it looks like Alameda, San Mateo, Santa Clara, Santa Cruz, and Monterey counties. They're also newer, so we don't have a lot of information about their expenditures. The next provides training, support, and legal information to community legal navigators and some direct ongoing legal services to those navigators' clients. They're serving Alameda, Contra Costa, Marin, San Francisco, San Mateo, and Santa Clara counties. And we expect their expenditures to be around 500,000. They mentioned in conversation that their expenditures recently surpassed that 500,000 threshold, and that number is relevant because we have an application requirement that organizations with expenditures greater than 500,000 must submit an audit. Those whose expenditures are under that threshold can submit a reviewed financial statement instead. So that number and threshold was relevant to them as an organization because they kind of recently surpassed it. The next provides direct immigration legal services, particularly to members of the LGBTQ+ community. They're based in Berkeley, but also appear to have a presence in the Central Valley. Their expenditures, most recently publicly available, were about 1.3 million. So they're a little bit bigger than these other organizations that we're speaking about. And then the last two QLSPs both provide direct legal services, largely in family law and evictions and landlord-tenant work. One of those is in Sacramento County and one of those is in Ventura County, and they serve those two counties exclusively. And their expenditures were a little bit lower, around 200 to 300,000 in the last publicly available tax documents. The one support center application that we're anticipating provides access to quadros or qualified domestic relation order products, and help legal aid organizations access those various products, and also provide relevant education and training. As a support center, they would provide those services statewide. And I actually didn't look into, I think they're a newer organization, so I don't think that they had their tax forms publicly available yet. But even if they did, expenditures are a little less relevant for the support center applicants because it doesn't have any bearing on their grant award amount. So happy to answer any questions I can on those organizations. Again, trying to stay relatively broad in the overviews, but that's kind of what the applications we're expecting to receive are shaping up to look like.
I thought that was really helpful. Thank you for pulling together the information, and maybe just remind us what the process is for a new applicant and how this committee is involved in that.
Sure. So a new applicant, all of our current grantees and any new applicants must apply annually for funding. That they must submit an audit or financial review by May 1st, and then their IOLTA and EAF application May 15th. This committee, as Eligibility and Budget Review Committee, is the committee that staff bring recommendations on eligibility based on those materials. And so if there's any issues with applications, those would come to this committee for discussion. This committee is the first, again, to make recommendations on ultimate eligibility of IOLTA EAF applicants. For most new applicants, I would say maybe not most, but many new applicants often need an eligibility review conference, or an ERC, which is an opportunity for the applicant, staff, and committee members to have a more robust conversation about their services. If there's any concerns staff or committee members have about their services and how they fit into IOLTA EAF eligibility criteria, that ERC is an opportunity to do that in a non-public meeting. And so that is something that we would ask, or will ask almost certainly, this committee to help us do after those applications come in, is hold those ERCs with the applicants that require one.
Okay, thanks for the reminder. Selena, you have your hand up.
Well, I just have a question, and because this is a public meeting, to make sure it's kind of set on the record, around what support is given to new applicants who apply for support center status, because that threshold, I have always cautioned people about applying for support center if they think they're between a support center and a QLSP, because it's just so much additional work. What is it that, if an organization applies for support center status, how do you walk them through what is expected of them?
Sure, that's a good question. So for any organization that's interested in potentially applying for IOLTA EAF funding, we recommend that they have a conversation with staff about what the eligibility requirements are and look like. Actually, just because of kind of the interim nature of my role as the IOLTA EAF lead and committee coordinator for this committee, the applicant here, support center applicant, had some conversations with another staff member who's out on leave right now. And so I'm not sure about the full nature of that conversation, but I think that's right, that support centers are in a unique role in that a new support center would need to be deemed. I think is particularly what you're talking about. There's a requirement that support centers are deemed of special need by a majority of QLSPs. And so if they're a newer organization that's trying to break into that eligibility category, there would need to be some discussion about how They are communicating with the current QLSPs so that they might be able to get that deeming through. Deeming happens after the applications come in. And so I think if we saw an organization that was applying as a support center that had never received funding before, there would be a robust conversation with them at that stage too about, okay, deeming is required as part of eligibility. Here's what the deeming process looks like. You would need to have a affirmative vote from a majority of the QLSPs and kind of help provide technical assistance at that stage as well. But again, I suspect, I don't know for sure, but I strongly suspect that some of that conversation happened with Erica before she went out on leave.
Okay, any other questions on this subject for Danielle? Okay, I think we're ready to go on to the next one. I think is this where you were going to provide some information about the organization we discussed?
Yes. Yes. So this isn't a new applicant, but they are an IOLTA EAF applicant, and that all of our current grantees must apply for funding each year. So this seemed like the appropriate stage to provide an update on Coalition for California Welfare Rights Organizations, or CCWRO. As you all well know, this is a current grantee. There's been some ongoing compliance concerns and conversations with the organization, so wanted to provide an update since our last committee meeting. As I'm sure many, if not all of you are aware, at the commission meeting at the end of March, the commission voted to deny CCWRO's 2023 EAF carryover and budget modification request because that particularly the carryover was denied. Staff has invoiced them for those unspent funds. They have not yet returned those funds, but they have until May to do so. We just sent that invoice out this week, and they have about 30 days to return those funds. As it relates to their HP or homelessness prevention grants, the commission at that same meeting found CCWRO non-compliant with federal grant requirements and is requiring that they submit various additional documentation, including monthly allocation reports and staff timesheets to receive their remaining HP3 funds, and also provide revised expenditure reports, allocation reports, again, various documentation on how they're spending those grant funds. Since that commission meeting, unfortunately, CCWRO submitted a late and substantively incomplete HP2 final evaluation report. I believe that was due at the beginning of April. I'm not sure how late that submission was, but I know it has since been late. Unfortunately, it's still substantively incomplete from the last update I received internally. And CCWRO has requested and is receiving some technical assistance and staff review of various materials related to their HP3 grant, as some of those deadlines are upcoming on both standard HP3 reporting and some of that additional documentation that was requested of them. So there's an ongoing conversation between the organization and staff on those HP3 materials.
Okay, any questions about this? Okay. Thank you for that. And I think we're going to go on to the next item, which is the audit extension requests, and those materials were in your packet. And I think Danielle will do a little brief overview of that.
Yes, perfect. Yes, so this is one of the memos posted as part of the materials for this meeting. As a reminder, audits are required as part of the IOLTA EAF application process. So this is in the State Bar rules that all applicants for funding, including current grantees reapplying for funding, must submit an audit by May 1. Of note, that is a couple weeks before the actual application deadline, which is May 15th. Staff have discretion to grant extensions up to the application deadline of May 15th. Beyond that application deadline, the commission can grant an extension upon showing of extraordinary circumstances, or recently there was a state bar rule that now allows the commission to grant an extension with conditions if extraordinary circumstances are not present. And what those conditions might look like is something like a letter to the organization's board alerting them that the audit submission was late, or requiring an corrective action plan from the organization asking how they will avoid a late submission in the future. The rules do not outline what those conditions can or should be, but there's some recommendations in the accompanying codification memo, I believe. Of note, the rules also state that the commission cannot grant extensions past the date that grant allocations are calculated, and that formula allocation is run typically right after the commission meeting, at which you all vote to either approve or deny the various applications, which is scheduled to take place at the August 9th meeting this year. Audit extension requests, these requests to extend that deadline typically are brought to this committee in June. And so when the committee meets next in June, that will be a robust part of the agenda. However, we received a couple early requests. And so as a courtesy to those grantees, wanted to bring them to this body early to give them some sense of whether or not those might be approved. And so those two grantees were Legal Services of Northern California, or LISNIC, and Capital Pro Bono. Both organizations, they're partner organizations, and so LISNIC's finance team actually undertakes all of CPB's financial and auditing work. So for the purposes of this, it's really one finance department that is requesting an extension. And they've had some transitions and unexpected medical events that have impacted that finance team. So they had a new staff, they have their current finance director is retiring, but also required a medical procedure and leave of absence in early 2024. They hired a new staff member who will transition into that finance director role when the current finance director retires. But that new staff member also required an unexpected pretty extensive surgery and leave of absence in the spring. And so that has delayed their ability to gather the various materials that they need for the audit and so forth. And so both organizations are requesting an extension to June 30, 2024. In past years, June 30 has been about the latest that staff have recommended extensions be granted through, because audits that we receive in July or August can make it very difficult for staff to thoroughly review all the application materials in time for that August meeting at which eligibility determinations need to be voted on. But June 30 has been kind of, like I said, the latest that staff has typically recommended extensions be granted, which is what they're recommending here. And while extraordinary circumstances are not required to grant an extension anymore, staff do feel like the circumstances here are extraordinary circumstances and would recommend that the commission grant the extension in this case as requested.
Thanks, Danielle. I think the other complication was that the audit firm that they were using, who does a lot of audit work in the legal aid space, wasn't going to be available, even though they might have been ready earlier. So I recollect that from your other memo. So it's just an additional extenuating circumstance, I think. So
Yeah. Thank you for mentioning
are
that.
there other comments or questions about this request?
I guess I had a question and a comment. The question is, Catherine, that you had mentioned in your email about an outside date for the audits, and that would be that August 9th meeting. Am I correct, Danielle?
Yes, yeah. So we Catherine had requested a little more information on if there's kind of the latest date by which you all could approve an extension, and yes, it is that August 9th date in the.
And then the comment is, it seems quite reasonable. I would agree to allow this one.
Great. So the next slide is
Oh,
the.
I'm sorry. Can we just?
Oh,
I thought Eloisa might have had a comment or.
Oh, I'm sorry.
I did not, sorry.
That's okay. You just moved forward, so I thought maybe you had something you wanted to say too. Okay, we can,
So the next slide is the resolution language. If you all want us to take a vote, we would need to change the resolution language so that it does not say the Eligibility and Budget Review Committee recommends. Maybe it's something like the members of the Eligibility and Budget Review Committee that were present on this date. Or we can have a discussion and not have a formal vote. I would turn to you, Catherine, on what you prefer.
I mean, if we can just have a vote, I think then it's just clear what we took. So if we can say something like the members of the Eligibility Budget Review Committee present at the, say, the 25th, maybe,
Okay.
meeting.
Duan, does that seem reasonable to you? And maybe Brady, if you're
Yeah, that's what I recommend, just to move
Okay.
things forward with the commission.
great.
It should be-
Let me just take a moment to make those edits.
I feel like in this case, it's helpful for the organization to know that the people present believe that this was justified and that are making a recommendation, just because puts programs in kind of a difficult place if they don't know the status, I think, so.
Yes, okay. So
And I'll also say, to my knowledge, this organization has a pretty stellar record of submitting everything on time. I don't really recall another time that they've requested an extension for anything, so that just adds to my agreement with what Angie said earlier about
this should be recommend instead of recommends, but barring that grammatical error or correction, does this wording seem okay to the members?
It does.
Okay.
And then with that, do we make a motion and vote on this since we're making a recommendation? So is there a motion to approve the resolution on the screen?
I'll move. I'll move it.
I'll second.
Perfect.
Great. So I will do roll call vote. Gonzalez,
Yes.
King,
Yes.
Klein, absent, Morales, absent, Vargas, absent, and Blakemore.
Yes.
Okay, so that resolution had 3 yeses, 0 nos, but it's not a vote of the committee as a whole.
Yeah.
Great. Okay.
Okay, so I think we are now on to the IOLTA EAF carry forwards and budget modifications. So
Yeah.
Perfect.
Great. So as you all may recall, the committee took a look at several various carryover and budget modification requests at the last meeting related to 2022 EAF and 2023 IOLTA EAF carryovers and budget revisions. As a reminder, for both carryovers and budget revisions, those that are smaller than 10% of the grant award amount do not require approval. Those between 10 and 25%, staff have the authority to approve, and those that are greater than 25% require commission approval. Because of staff oversight, there was one carryover request that required commission review that was inadvertently excluded from last meeting's materials, and so we're bringing it to you today. I will say it was very much just a staff error. This request was submitted timely. And this request is coming from Legal Aid Society of San Diego. They're requesting a carryover of 45% of their 2023 EAF grant. And they're requesting the carryover because one of their staff teams that works on SSI benefits was temporarily transitioned to another source of funding that I believe was expiring. It has since been transitioned back to their EAF grant funding. And so they fully expect to be able to spend down this grant in addition to their 2024 EAF funding. And to be consistent with the requests that were reviewed and approved at the last meeting, staff would recommend approval of this carryover request as well. As a reminder, at the last meeting, the committee recommended approval for carryovers as high as 69% of the grant award amount, and even tentatively recommended a carryover of 100%, but that was ultimately revised down to 50%.
To the information, are there questions or information that any of the committee members want to share about this?
Hearing none, the next slide is the resolution, which again, I can revise the language before we vote.
It's great, thank you.
And pulling that back up.
That's great, Danielle. Thanks for making all the adjustments in real time.
No worries. Okay, so that is the motion before you for consideration.
Any discussion about the resolution? And if not, would someone like to make a motion?
I'll move.
Thank you, Alwina.
I'll
Angie?
second.
Thank you so much. I think we're ready for a vote.
Great, Gonzalez,
Yes.
King,
Yes.
Klein, absent, Morales, absent, Vargas, absent, Blakemore.
Yes,
Great, that resolution received 3 yes votes, 0 no's, but again, is not a resolution passed by the committee as a whole.
sounds terrific. Thanks for that. I think what we'll do for the next item is have you go through the presentation. This is about the ILAW report activities and a question about one. I think it'll just be helpful for background. And I'll just note that we also received from Kimberly, I think, although it could have been Shannon, a written comment, and then we know that there's some people from the organization on the line, and we'll take those comments before we start our discussion, I think. So I just think it'll be helpful grounding if we're all thinking about the right information.
Sure.
Okay.
Thank you. That approach sounds reasonable to me. So the next item is around impact litigation and advocacy work, or ILAW reports for 2023. You may recall I gave a brief overview of what ILAW is at our meeting last time, but I will give it again here as well as a reminder. So we require ILAW reports be submitted by our grantees, and these reports serve 2 purposes. They are evaluative in that they allow the staff and committee and commission to review 2023 activities and accomplishments, and they are important for determining eligibility because we want to ensure that this work is qualifying and that organizations adjust their qualifying expenditures as necessary for 2025 IOLTA EAF application. So if any work that they submit in an ILAW activity is found to be non-qualifying, they would need to deduct the relevant expenditures from their qualifying expenditures in the 2025 IOLTA EAF application. So in the ILAW report, grantees are asked to report on their top 10 impact litigation and advocacy activities in total, on which at least 50 staff hours were spent. And so that is impact litigation, class action cases, legislative or administrative advocacy, activities that impact a group or class of clients or group of class of people beyond their individual clients. And so then staff review these and look at both the forum and the target population of those services. And state bar rules require that the target population is either majority indigent or it disproportionately impacts indigent Californians.
Don't you say a word about what you mean by the review of the forum? Okay.
Sure. So that is about the case. If it's an impact litigation case, the actual court at which that case was heard or submitted, largely to ensure that it's in California. And so, and then staff and both EBR review these activities where review these activities and then bring to EBR any activities where the qualifying nature of the work is in question. And so I'll go to the next slide. It gives a little bit more information on what is and is not qualifying for both QLSPs and support centers. So for QLSPs, we want to ensure that they are civil legal services. The definition of legal services changed recently, so I'll go into that momentarily. But we want to ensure that they are civil legal services primarily for the benefit of indigent persons in California or with a disproportionate impact on indigent persons. They must demonstrate through objective information that the majority of those impacted are indigent, or again, that the activity has a disproportionate impact on indigent persons based on both the nature of the activity and its anticipated outcomes. And advocacy work is not specifically defined, but generally we would accept work that relates to drafting a bill, supporting a campaign to enact change or enforce law or regulations of issues that are important to indigent persons. As I mentioned, the definition of legal services recently changed in state bar rules. Legal services means work that uses legal knowledge and skills to create, advance, protect, or enforce the legal rights of indigent clients or communities. That can include both representation and non-representational services, and those services must be performed by or supervised by an attorney. It might also include complementary services like social work services, for example, so long as they advance the legal outcome and serve as an integral part of the attorney's strategy in a legal matter or case. And again, that the attorney directs the work in that matter or case. Okay. And for support centers, what we might see is they should be providing legal training, technical assistance, and advocacy support for civil legal services without charge. Impact litigation would be considered direct services unless they are co-counseling with a QLSP or a pro bono attorney, or they have the case has been referred to them by a QLSP. And so any impact litigation work should have that co-counsel or referral to be determined qualifying for a support center. And as far as the advocacy activities, like a QLSP, it's not explicitly defined what an advocacy activity is, but that work has generally been accepted so long as it is helpful to the needs and service priorities of the legal aid community. So what is qualifying for support centers and so as it relates to advocacy is admittedly pretty broad.
And in this case, I'm sorry, just so we're clear, this is a direct legal service, not a support center, right? Is that right? Or
so, I'm sorry, I see Dwan is nodding. Can you repeat the question, Catherine?
I was just saying, because you gave us both standards, what is a QLSP standard and what is a support center? I just want to make sure we're focused on the right one. I think this is a QLSP program, but I might be mistaken.
The one that I will bring up later, yes, is a QLSP.
Perfect,
Yes.
thank you.
Of course. And so what the staff review process looks like for ILAW activities, staff review all of the activities that are submitted, and any that are clearly qualifying are anticipatorily approved. And then also activities that were reviewed and approved by the committee in past years are also generally approved, so long as there's not a substantive difference in the work that causes concern for staff. If there are activities that either the grantee submits and says explicitly, we don't feel that this is qualifying, or staff raised concerns about and the grantee ultimately agrees to be non-qualifying, those activities are marked as non-qualifying and will be deducted from the organization's expenditures in their 2025 application. And then staff elevates to this committee for individual review any activities where there's lacking clear support that it is demonstrating, or excuse me, is impacting a majority indigent clients or disproportionately impacting indigent individuals, or if staff and the grantee disagree on whether the activity is qualifying in nature. So after that staff review, there are two activities that staff is bringing to the group for individual discussion today. And as Catherine mentioned or asked, both of these activities are from one organization that is a QLSP. So that QLSP is Asian Americans Advancing Justice Southern California. The first activity is a dual language immersion, Asian language bilingual accreditation activity. The organization advocated for budget language for an Asian language bilingual teacher education program. In previous ILAW reports, they had reported their work on that activity, and they're now conducting administrative advocacy and providing community outreach and education on that work. A similar activity was found non-qualifying last year. Staff had some questions about the nexus to indigency, and at that time, the organization did not have relevant data to provide. However, upon follow-up with the organization this year, they did provide greater data about LEP students, limited English proficiency students' likelihood to be indigent, and the disproportionate impact of having greater language accessibility on those students. And staff did find that compelling. And so staff is recommending that this be found qualifying. I will flag, since posting, there's been some concern or discussion internally about whether these services are fully legal services, since that does mention community outreach and education. So that was something that I would invite the committee or members of the committee present here today to discuss or provide any feedback on. Catherine, would you prefer that I stop after each activity and allow some discussion, or do you want me to report on both?
Let's just report on both, and then I think we'll hear from the program next, unless a committee member wants it a different way.
Great. The second activity is an independent redistricting commission bill that the organization is advocated for in 2023. It's a bill that would mandate the use of independent redistricting commissions, in counties, cities, and districts that are larger in size. Similar activity work was found non-qualifying in 2021 because of an unclear nexus to indigency again, and the work is pretty substantively similar this time. Staff are concerned that there's not enough evidence of disproportionate impact on indigent Californians. The organization provided robust information on the impact to Californians of color, but that nexus to indigency wasn't as readily apparent to the staff that reviewed and discussed this, which is why in the memo we are recommending this be found non-qualifying based on the evidence submitted.
Okay, thanks for you're done, right, Danielle?
Yes. Yep.
Perfect. Let's hear from the program next, and then we'll have a discussion among the three of us that are here today.
And I can also stop sharing my screen if that's helpful.
Yeah, I think so. There is Corey who has raised their hand. Welcome.
Hi there. I can't quite figure out how to turn my camera on, but can you hear me okay?
We can.
Okay, great. Thank you so much for having me today. My name is Corey Rosella, and I'm the Vice President of Programs at Asian Americans Advancing Justice Southern California, or AJ SoCal. And again, thank you for the opportunity to provide public comment in support of our written comment submitted by our CEO, Connie Chung-Jo, earlier this week. We appreciate the staff's thoughtful analysis and recommendations about our ILAW activities, and we ask that you find both of our advocacy initiatives at issue today to be qualifying. First, we ask the committee to support the staff's recommendation to deem our dual language immersion and Asian language bilingual accreditation work as qualifying. As we submitted in support of our activities, data shows that limited English proficient students are disproportionately indigent, and we know that limited language access decreases access to safety net services. As the demographics of our state continue to evolve, our work in this area is critical to advance more culturally competent and linguistically appropriate legal and social services and providers. Second, we asked that the committee also deem our independent redistricting work as a qualifying activity. In California, redistricting has been used as a weapon against low-income and BIPOC communities, and AJ SoCal's redistricting work seeks to combat that through policy advocacy, community engagement, and litigation enforcement. Though redistricting may generally be considered not legal work focused on indigent persons, our work is. Our redistricting work is led by our voting rights and impact litigation team and supported by our demographic research project. And we are prepared to enforce those rights through litigation, and much of our work is looking for opportunities to advance litigation where we find problems. And so our work focuses on Asian American and Pacific Islander enclaves that have low levels of English proficiency, lower acculturation, and low income levels to ensure the most disenfranchised and marginalized members of API communities are not left out of the process. For example, our impact team and demographic research teams also focused in Los Angeles's Koreatown, as well as Samoan and Cambodian communities in Gardena and Long Beach. All of these are areas for ethnic communities that are largely low income, highly immigrant, and marginalized from political systems. And although redistricting work has previously been found to be non-qualifying, we urge the committee to reconsider this work for this year and going forward. To be responsive to the growing movement for racial justice and cultural sensitivity, we ask that you examine the changing viewpoints around Asian Americans and assumptions about our community's income levels and needs. API communities are now the fastest growing ethnic population in the state, and as we look at the diversity among API communities, AJ SoCal's work focuses on the vast disparities in income level, English proficiency, and access to justice. As such, we respectfully urge the committee to deem these two activities as qualifying. Thank you.
Thanks. Thank you, Corey, for being here and presenting the information. We appreciate hearing from you. Brady has his hand up, so let's take Brady's comment next, and then we'll talk as a committee.
Corey, thank you. I actually had a question, and I know that the recommendation focused more on the nexus to indigency. I had a question about just making sure that these are legal services as defined in the statute. So what, I noted that it's the litigation unit that's leading it, but what, and you're looking for litigation opportunities, but I guess what is the actual work that's being done?
So for the redistricting, is your question primarily around the redistricting?
Yeah.
Or both of them?
Yeah, I guess, I mean, probably both. It seemed like sort of the advocacy was a little bit more clear on the first one, but yeah, actually, I think it would be helpful to just sort of review what is actually being, this money being used for.
So
other than attorney time.
Yeah, so part of it is really in support of legislation. And let me get the bill number. The redistricting, we were supporting a bill, AB 1248. So it was policy advocacy. And then the work that we did on the ground was led by our impact litigation and demographic research teams. So it's a combination of those two that we believe is sufficiently legal activity.
But is the grant money, what is it actually being spent on? I mean, if it's being spent on an attorney writing a, reasoned letter, or, that's clear, and it doesn't have to be that, but what is the work? Is it paying for door-to-door outreach, or what? I just want a sense of the actual what is being done in these projects.
Right. So, I mean, a lot of it is community engagement. I think that is part of what we were trying to do. The work we did in Koreatown was to kind of target and provide advocacy to look at how Los Angeles is redistricting its city council seats. So in that way, it is a kind of community engagement, but it's led by our impact litigation team. So, right, it's paying for lawyers who are helping to lead and engage in this work.
Okay.
So Corey, it's Catherine. I might be getting confused now with the
Yeah.
questions that were being asked. So the lawyers are going out and doing what with the community then? So I appreciate it's lawyers, and it makes sense to me, like the policy work, legislative advocacy component is done by a lawyer. I appreciate that, but I think I'm now lost as to what lawyers
Yeah.
doing when they go into, like you gave an example, they went into the Korean community and they did what?
Right. So they are going in and we are working in coalition to help with civic engagement around redistricting in these areas. And that is informing our policy work in support of the legislation that we co-sponsored.
But like, is there a community meeting and the lawyer is spending an hour of their staff time leading a discuss, like, what are the lawyers doing?
Yes. So they're going, so I can like pull specific hours on this. I think most of the hours were done in support of the legislation, but the legislation is in support of what we're also doing on the ground in coalition. They are holding community meetings. They are, I'll have to check if they've done like specific advocacy letters around this, but it is mobilizing community to look at how city council districts are drawn in Los Angeles.
So Brady, while you're thinking, I'm going to view the pen in your mouth as thinking. I'm going to ask Angie she seems like she has her hand up and maybe a question.
But it's along the same line. It's like, is it that a lawyer is physically going to a community group and talking to them about how to get redistricting, and to encourage them, like to go to city council meetings or whatever that would take? Is it actually an attorney doing that? Or is it like community organizers and there's no lawyer involved in it?
Yeah, we don't have any community organizers per se on staff, so it is our staff attorney who's doing the work.
So they're physically going out to the community, they're using their time.
Yes. I'm going to, hold on. In our written comments, we link to an article that features some of our work, if that is more helpful to if that is helpful.
Sure.
Okay. Oh wait, there's not a chat here, but yes, so a staff attorney is going out into the community doing the work.
Okay.
Can I ask you, you referred to AB 1248, is that what you said?
Yes.
And what does that bill actually do?
AB 1248 would establish independent redistricting committees in cities that have a population of 300,000 or more. Part of the materials that I think that we submitted shows that poverty rates in those cities of that size tend to be higher.
Looks like I mean, that's sort of a separate question. Is it substantially impact indigent people? It looks like you said 22%.
In
Yeah,
Koreatown, yes.
I'm looking at what the actual report, which is attachment B that you submitted, right? So you targeted communities, but the impact of the redistricting piece for indigent people is 22% of those. That's the percentage of people that are living in those areas, I think. That's how I read that.
Yes, I would agree with that reading.
I'm not sure what that database source was, but I checked it against LA City, and I guess LA City is 16%. Had that as the poverty rate, so it is somewhat elevated over the city at large.
Go ahead, Tuan.
On just the legal services piece, I feel like if it's a staff attorney doing it or a directing attorney, an attorney position, it feels more to me persuasive that's legal work.
Yeah.
But the indigency, I'll defer to the group.
And just I just took a quick look at the application. So we're talking 175 hours on the language and 875 on the or I might not be saying that, it's somewhere in there, 800, about 200 and about 800 on staff hours on the
Yeah, and I will say that some of the larger amount spent on redistricting was done by our policy advocates who are not attorneys, but do work in legislative advocacy.
And what were they doing?
They were doing also coalition work and doing legislative advocacy. So educating legislators about the bill, going to and testifying at committee hearings, legislative activity.
So that seems qualifying, right, Brady? That piece of it, yeah, as well.
Yeah, where it gets fuzzy and where it gets tricky is sort of when it's more like organizers going door to door and just trying to well, on the one hand, we recognize that a lawyer could be qualifying for a lawyer to do a training. It's more concerning and further from the intent when we're talking about just organizers getting just out there.
Yeah, we don't have organizers on staff. We have a community engagement team, but they primarily work on our in-language social media as forms of outreach. So they're not, we didn't count their time on this.
I think Eloina has her hand up, so.
Yeah, so regarding the hours, I was looking at the State Bar Rule 3.674F. And so I think, is it so long as there's at least 50 hours plus, meeting the other criteria, then it would qualify. So does it, I guess, are we looking at how many hours, so long as the attorney, let's say, spent 50 hours plus, then it meets that criteria or that element? Is that, because I know they reported maybe 800 hours, but I don't know how many hours the attorney actually spent on this work and whether or not it's even sort of an issue.
So that rule around 50 staff hours relates to the threshold at which they need to report on the advocacy activity. And so if the advocacy activity required or took up 50 or more staff hours, regardless of who those staff were, they are required to report on the 10 largest activities that fall in that bucket. So that's more of a reporting threshold.
Yeah, I still think the question is interesting. So there were 800 hours spent on this initiative. And of those 800 hours, is it possible for us to know what number of the hours were done by an attorney and what numbers were done by non-attorney staff?
It is possible. I don't have that readily at my fingertips, but I'm happy to submit that information to the best of our ability to State Bar staff.
That'd be great. Thank you. Thanks for your willingness.
Of course.
So I guess the second prong, Eloina, to your point of just, who was the work done by and what was the work? I think that's what we've been talking about. I think for the redistricting, I think there's a second question about, is there a substantial benefit to indigent people or are they disproportionately impacted? And I think this issue came up before, and that's why I was interested in kind of the poverty rate, which is 22% is impacted. And I think Brady just said something in a different county, the poverty rate, I think Los Angeles City, maybe the poverty rate was lower. And I think one of the things we have to wrestle with is this primarily a service to indigent individuals? Are they substantially impacted by this particular, I'm now talking about redistricting, because I think the analysis on the school side might be a little bit different. But anyway, I think that's another question we have to satisfy ourselves about. Do people have thoughts about that? Including staff, I think. So if you have a thought about how you might look at that, that would be helpful. And Eloina has her hand up. And then Judge Seligman.
Judge Seligman, I know you have to leave. Do you want to go first?
Yeah, just briefly, in terms of adverse impact standard, I mean, assuming that Brady's statistics are the relevant overall population, which is what I think you were suggesting. You have a poverty rate in the Koreatown area that is at least 40% higher, if not 50% higher. And if you used what would be traditional statistical adverse impact analysis, that would show an adverse impact. You know, the EEOC used to have a 20% rule years ago for enforcement. If something was 20% off, that was a sufficient prima facie showing. Now, that's not a statistical analysis, it's a rough one. And I don't know that we should be applying formal statistical analyses here. But it seems to me there's a sufficient showing that the redistricting here could be have of a benefit to individuals where there's an adverse impact in the differences. It's the only comment I was going to make.
Okay, thanks for the information. I think the standard substantial or disproportionate. I'm not looking at that slide anymore, so
It's sorry. It's primarily impact or disproportionate. Is primarily for the benefit of indigent persons or disproportionately impacts indigent persons. I mean, I guess the additional question is, I guess we're just assuming that you know, redistricting is not a or is a zero-sum game. Like we're assuming here that the advocacy is you know, going to be taking disproportionate power away from the wealthier enclaves of Los Angeles. Not that, you know, one could imagine that the redistricting benefits these, but hurts other disadvantaged groups.
And that is something that we raised in our comments, that we didn't focus on other Asian American Pacific Islander highly concentrated areas like in San Marino near Pasadena or Rancho Palos Verdes, like very high income, but also high rates of AAPI populations. Like we did not spend our time and energy there.
Yeah.
And that, you know, our work with Samoan and Cambodian communities, they're even more impacted by poverty than the communities in Koreatown. There's an estimate that there's 33% of Cambodians living in Long Beach are below the poverty line.
And so is this redistricting? Because you mentioned it's a bill. Are we talking
The bill,
council districts or supervisory or all of the above?
it would be redistricting commissions, I think, for city and county.
Okay.
It didn't pass, so it's a little bit of a moot point right now.
Right.
But
No, just because
yeah.
when I looked deeper into what does the 22% mean? I was comparing to the LA City.
Yes.
Sounds like you were also looking at possibly and deciding not to represent groups outside of the city.
Right.
So Eloina, you had a comment, I think.
Yes, so AB 1248, we know it didn't pass, but in terms of the advocacy work or policy work, if it had passed, it would have applied to all of California, not just to Koreatown.
Yeah, I think it's to any city or sort of area that had a population of 300,000 people or more. So
Okay.
probably not applicable in some rural cities that might not have a population that high. But if you looked at LA, I think most cities, by way of example, will have population of that size.
Okay, and so I was looking at the executive summary and at the bottom of page 5, it appears that the research provided appears to indicate that people of color are disproportionately impacted by gerrymandering, but does not necessarily indicate indigent Californians are disproportionately impacted. But I'm wondering if there was data or research provided by AJ SoCal to demonstrate that indigent Californians are disproportionately people of color. I don't know if we have that data, because if the research that they did provide appears to indicate that people of color are disproportionately impacted by gerrymandering, then if indigent Californians are disproportionately people of color, then that could potentially meet the threshold requirement that this activity qualifies as impacting primarily or disproportionately indigent Californians.
Sure. Oh, yeah, please go ahead, Corey.
Oh, I was gonna say, I don't think we made that exact point in our response, but I think that we can find support for that proposition. The indigent Californians are disproportionately people of color, or maybe rather that people of color are disproportionately low income. Based proportional to their representation in the general population. So along with the hours, the breakdown that we are going to submit, I can also submit some information on that point.
Okay. I mean, my quick Google search, which I'm not gonna verify these are,
I'm doing the same.
AI generated thing that's not true. So with that disclaimer, it says Native Americans have the highest poverty rate by race, 25%, Black Americans second highest at 20.8, Hispanics third highest at 17.6, while white and Asians have poverty rates of 10.1. This is like statewide data, so it's not going to mirror kind of the numbers you have there, but that's what it says. But anyway.
And a lot of our work is on disaggregating data so that we know this very often in Asian communities, that the average gets pulled up, but if you disaggregate for, Southeast Asian communities, Pacific Islander communities, their poverty rate is far higher than East Asian communities.
Yeah. Bye. Thanks, Judge Solomon, for joining us. Good luck with your calendar. Okay, are there any other comments people want to make? I'm gonna maybe suggest some. So it seems like there was a staff recommendation to support the first issue, which was the bilingual certificate. And I believe that has a disproportionate impact on school-age children. So I want to see if there's any discussion about that, or whether we're prepared to support that recommendation.
I'm ready to support that.
Okay, Elowina, that good with you?
Yes.
Okay, so let's just take up that one, because it seems on the second one where there's the possibility of getting some additional information that we might want to have before we conclude that one. So if it's possible to separate them, Danielle,
Yes.
and change them.
I'll put it on a different slide.
You just take your time. We're doing terrifically with our time today. So.
We are not in a rush on this agenda today. Okay. So I will from current slide and then share my screen. Oh, that is not. the right slide, but we should be able to get there. Did this up, oh, excuse me. I was trying to prep us for the, oh dear, okay. PowerPoint is getting angry with me. Okay, resolved that the members of Eligibility and Budget Review Committee present on April 26th find qualifying for the purposes of 2025 IOLTA EAF application, all activities that staff recommends without reservations, and the following activity elevated for discussion. Would be a motion to consider.
Okay, any questions about that motion? Do we need that and the following activity elevated for discuss? I'm not sure what that means in this context, I guess. So aren't we just recommending this to the commission?
Yes, so this resolution is in the same format as prior meetings where the kind of bucketed everything that staff essentially didn't raise for discussion, and then separately those that they did. But if you prefer to not use that format, that's fine too.
It's okay, as long as it works for you. I don't care that much. I just was a little confused by the language.
Sure.
So,
Yeah.
the discussion about this. Okay, I think we're ready to vote on this part.
I'll move.
Thank you, Eloina.
I'll second.
Thank you, Angie. Want to take
I'll roll call.
Thank you. Yeah.
Gonzalez,
Yes.
King,
Yes.
Klein, absent, Morales, absent, Vargas, absent, Blakemore.
Yes.
Great. 3 yeses, 0 nos. And as I said with the earlier action items, not an action by the committee since we do not have quorum.
Thank you. And then it seems on the redistricting one, there was some outstanding information that I think would be helpful for staff to look at. There's the question about the amount of time that an attorney spent on the work. There's some questions about sort of the additional data relative to the populations that were served. So since we can't really make a formal recommendation, I wonder if it would just make sense for that information that was requested to go to staff. And Dwan, tell us, like, should staff then just make a recommendation to the full commission, or should two people on this, 2 of the 3 of us look at it with you? And
Yeah, that's your preference. Do we have a meeting before the commission meeting? Danielle, why
Yes.
don't we just bring it back to the committee then?
oh, that's great. Okay, why don't we do that?
Okay.
Then we'll have the rest of the information, and you all can look at the information, and
So we'll send it out to the full
yeah,
committee.
that would be great.
Okay. Well, that is the last item on the agenda for today. As it relates to that June meeting, I just wanted to flag that agenda might be quite heavy, and I think that's scheduled for 2 hours right now. So, Dwan, I don't know if we want to discuss the
Yeah, I think we should
possibility of
extend it
lengthening
to 3 if that's
I
possible.
don't know that I
No?
can do that.
Okay,
So
okay. If
Okay.
you can't do
hold
that,
on,
then we'll
let me
make it work.
but just remind me what day it is. Like, I
I
feel
believe
like
it's June 12th. I'll double check, but
oh no, I can do it. If it's June 12th.
Okay, that would be
Yeah.
great, because we also, we had another agenda item prepared for today that we actually pulled because we weren't ready yet about budget carry, and so that closeouts, I'm sorry.
about closeouts, yeah.
Oh, I know what you know what, so I'm not gonna promise I can stay an additional hour, but if I can't, someone else can just chair that part of it.
Yes, yeah, we can have a.
Because I think this is a
remainder.
pending date for this, there's a bigger conflict
Okay.
that, day, so, but it's fine.
And that June meeting is also when we would discuss the rest of the late audit, or audit extension requests, and also any late application submissions, since by May 15th, or excuse me, because the IOLTA EAF application deadline is May 15th.
That sounds great. Okay. Any other comments for today? Thanks to both of you for participating. I think we did a good job with our small little group, so I'm glad we could actually get through all of that. I think that'll be helpful, given apparently how long the next agenda will be. And thank you to Corey and people who made the comments. That was helpful information. Okay.
And thank you, as usual, to the staff for having everything so well organized.
That's exactly right, Angie. I agree with that. Thank you for saying that. Okay, I think we are good, and we're going to be adjourned.
All right.
Thank
Bye.
you.
Thank you.
Thank you.
Bye.